Well, a busy day in Supreme Court today. Let's start with the case concerning so-called freebies. The Supreme Court has observed that nobody can deny this is an issue and has called for a debate. The court has also taken exception to comments made by Tamil Nadu's finance minister, questioning the court's jurisdiction in the matter. Ashmit joins us now with more on what transpired in court and what next now. Ashmit.
Well, the Supreme Court, in fact, deliberated at length on the issue of what freebies are and how to proceed with that. To begin with, the Supreme Court noted that it's difficult to come up with a watertight definition of freebies, citing the example in Bihar where cycles were given to females and that led to upliftment. But nonetheless, the Supreme Court did observe that this is a serious issue, definitely merits debate. And towards that end, the Supreme Court appears to be leaning in favor of constituting some form of committee that will comprise of various experts that will, in fact, deliberate on the issue. In fact, the Supreme Court even asked the question as to who would be a fit candidate to lead such a commission. The Supreme Court observed that ideally it would have wanted for this debate to take place in Parliament, but that now that it has been seized of the question, it wouldn't mind delving into the subject. In fact, the Supreme Court even made observations with respect to certain responses coming from certain quarters that have in fact raised questions regarding the Supreme Court's jurisdiction. Nonetheless, in response to some of these questions, some interesting answers emerged. Kapil Sibal, who has been requested or invited by the Supreme Court as an amicus in this matter, suggested that under the FRBM Act, there is already fiscal discipline rules in place. 3% cap is placed already on states, and that can be a mechanism used to check for fiscal indiscipline by ensuring that there are lower grants issued to states that have breached those limits. That was a suggestion which in fact was echoed by the Aam Aadmi Party as well. The Aam Aadmi Party, represented by Abhishek Manu Singhvi, argued that to monitor or to regulate promises or election speeches would be tantamount to issuing a gag scheme that would be violative of free speech laws, and that the only feasible way to go around it would be in fact to rely on the FRBM targets. The centre, however, had a very different take on all of this. The centre said that, look, this is something that desperately needs the attention of the court, needs some form of regulation, citing issues in the power sector, saying that freebies issued by various governments are bordering fiscal indiscipline, and that the political parties cannot endanger the economic health of the country for seeking the top seat, the top position. The Supreme Court for now has stopped shy, has paused before making any orders. The hearing, we understand, will continue tomorrow, and that's perhaps when we can expect more clarity.
Ashmit, many thanks for joining us on that issue, but don't go anywhere because we're back with you on another case that you've been tracking. The Supreme Court has also agreed to hear a plea filed by the Indian Medical Association against yoga guru Baba Ramdev. Ashmit, take us through what that's about.
Well, this is not a new issue. In fact, it was raised first before the Delhi High Court. Now it finds itself before the Apex Court. And this is pertaining to various advertisements for Patanjali products that had been, in fact, issued in various national publications. The IMA, or the Indian Medical Association, has called it a smear campaign, saying that frivolous pieces of information and claims have been put out in various national dailies. Allopathic medicine has been, in fact, questioned. In fact, certain advertisements even claim that doctors themselves have suffered fatalities despite being doctors themselves and being in charge of allopathic medicine. And such claims, in fact, was something that the Apex Court took objection to. The matter was placed before a bench headed by the CJI. The CJI questioned Baba Ramdev's counsels that while he may be an authority on issues such as yoga and Ayurvedic medicine, it does not endow with him any right to, in fact, hit out at allopathic medicine, that is an alternate medicine that he is propagating, that's Ayurveda. But there is, no one can stake a claim to Ayurveda being the answer to all forms of illnesses, and that this is something that even the centre will have to consider. The IMA essentially is seeking action by the centre to be initiated against Baba Ramdev, and on that count, the Supreme Court has issued a notice in this IMA application to both Baba Ramdev as well as to the centre, and has sought a reply from both the parties on the concerns that have been raised by the IMA and the call for action against Baba Ramdev. Centre will have to reply on that.
Ashmit, many thanks for joining us, and we're not done with news from court. The Supreme Court has formed a 5-judge constitution bench